We are live.
All right. Welcome to another day of House Judiciary. We are in week number 2 of the 2022 budget session. We are continuing to work through House bills. We have 3 House bills today on our agenda: House Bill 51, House Bill 71, and House Bill 88. And that is the order in which we will take up those bills. Carol, will you please call the roll?
Representative Crago.
Here.
Representative Larson.
Here.
Representative Oakley.
Here.
Representative Provenza.
Here.
Representative Rodriguez Williams.
Here.
Vice Chair Washut.
Here.
Representative Yen.
Here.
Representative Zwanitzer.
Here.
Chairman Olson.
Here.
All present.
Excellent. Thank you, Carol. All right, committee. We will start with House Bill HB 0051, prohibiting the release of mugshots unless convicted. We have Representative Banks here, sponsor of the bill. Representative, go ahead and introduce yourself and walk us through your bill.
Good morning, Representative Chad Banks from Sweetwater County, House District 17. I bring before you this morning House Bill 51, which is brought to you from citizens in my community that are really concerned about this. I did want to preface this by saying this bill is not meant to disparage law enforcement or their efforts in any way. In fact, my sheriff actually had intended to testify this morning, but his mother passed away on Friday, so was unable to be here this morning. This bill will amend, as you see on your bill, the bill before you will amend Wyoming Statute 7-19-106 and creates a new subsection. That statute deals with criminal history, records, and access to and dissemination of that information. And the new subsection that will be created is Section O. The bill applies both to the state of Wyoming's Department of Correction and our county jails within the state. I'll kind of walk you through what's in here. You see where it does apply to both of those at the bottom of page 1, the Wyoming Department of Correction and county jails. And then page 2 and 3 are obviously the changes and the suggested new subsection in the bill, which prohibits the release of photographs. It does have some strong sideboards on here, and we'll kind of get to those about how law enforcement can still utilize those mugshots when needed. Then lines 13 through 17 kind of talks about the photograph, when those are allowed and when they are not allowed, when you can disseminate those photographs. One of those options is when the criminal offense is based on the conduct for which the individual is already incarcerated at the time of the photo. And then on page 3, it talks about where the judge can order the issuance of mugshots. So it's further a legitimate law enforcement interest, or if the individual in question is a fugitive with imminent threat to an individual or public safety, or obviously to assist in apprehending that individual and be on the lookout for, so they can eliminate that threat. I'll tell you a little bit about how this came about in Sweetwater County. So, and my county is not the only county where this happens, but we have 3 electronic news media sources, using the word news media in quotations, and their first post every morning about 6:30 or 7. And I did share this with you in an email last week, if you all saw it, is the mugshots of those folks that are arrested the next day. And that in my community has become a huge source of rumor, of gossip, of, just kind of water cooler fodder. And those mugshots obviously stay around forever, regardless of if those people are ultimately charged, if those charges are dropped or what happens. And I believe we do have a gentleman who hopefully will be able to testify this morning where his charges were dropped and that mugshot still exists. I did a quick internet search yesterday of how you could get rid of those things. And you all probably are aware that there are hundreds of firms out there that offer that kind of resource available online, ranging from thousands of dollars upwards to $5,000, $7,000, $10,000 just to kind of get rid of those mugshots. And obviously that doesn't completely get rid of it. You can't really unring that bell. So like, for instance, again, going back to my community, once those mugshots are shared in a morning, they often go viral. In the one case of the gentleman that you may hear from, Wing Lu, who is a businessman, that mugshot was shared multiple times. His charges were ultimately dropped, but there's no way for him to then get that off and kind of build back his reputation for those folks that shared that. There are still opportunities, and I think I shared this in the email with you last week, where other news sources just share the listing of who was arrested. And that's obviously much more impactful than when you see their booking photo. So with that, I'll be happy to answer any questions.
Committee? Representative Banks, let's see, where was I at? On page 2, the language under Romanet 2, prohibiting the release of a photograph taken during the process of admitting an arrested individual into custody. Explain to me how is that defined? The process of admitting an arrested individual into custody, that point in time, when does that exist?
So once that individual is booked into the county jail, or in most cases, obviously that would not apply to the Wyoming Department of Corrections, because folks aren't going directly to the Wyoming Department of Corrections. But once you're booked in and they take your booking photo, then that's where that becomes something that isn't shareable in mass.
Representative Oakley and then Vice Chairman Washington.
Thank you, Mr. Chair. Good morning, Representative Banks. So I have a couple questions. I'm wondering if you would be open to something to make it broader. What I see here, and I'm talking about something like around 2 or 3 to add for any legitimate, that it could be released for any legitimate law enforcement purpose. The way this reads, a judge has to order it. And what I'm concerned about is we use them for identification in the county attorneys. And there's a lot of different law enforcement. I mean, that's what you have as identification. So there's a use for these. That's the reason, they're taken. And I think this might be, this might go too far in saying that a judge has to order it, because while you work closely together, those certainly, it's not the same agency. So what are your thoughts on broadening it and basically having, can be disseminated for any legitimate law enforcement purpose?
Representative
Chairman.
Banks.
Chairman. Yeah, I think that would be fine. I mean, our intention with the bill is by no means to hamper or hinder law enforcement or tie their hands. So I assume you're referring to page 3, Romanet 2, at the very top there. So just the further, just change that to, we could really take out the judge orders, but a furtherance of, absolutely, that would be consider that sort of a friendly amendment for sure.
Representative Banks, with that, would you still leave the language about the judge's order, just have another exception, which is for any legitimate law enforcement purpose?
Chairman Olson, I would think, in my mind, and I'm by no means an attorney like many of you, I would think we would want to leave that as well, in case maybe there is an opportunity where law enforcement doesn't want to release it, but some others find that it would be necessary, where they could then go to a judge and request that versus always just law enforcement.
Yeah, please, Representative Oakley.
Thank you, Mr. Chair. We can discuss wording, but at this point, what I'm seeing, it doesn't seem to me that would make any sense, because then one would be a judge has to order it upon a finding, and then also just for any legitimate purpose without a finding. Kind of, that seems kind of nonsensical to me, unless there's a difference. When is it that a judge has to make a finding to disseminate it for a legitimate law enforcement purpose? And then, so I would actually be for not having it that a judge orders it and a finding, and leaving just the end, which is if the dissemination is in furtherance of a legitimate law enforcement purpose or interest. That's where I would get to, because I think if you had both of them together, that wouldn't make sense. But I guess we can do that a little more when we.
Yeah, Representative Oakley, I guess what I was thinking of, and maybe you can help with this, is not the judge ordering the release for a legitimate law enforcement interest, but a judge ordering a release for any other reason. Is there
Okay.
another
I see what you're
entity
saying.
or agency that might want to request it, or the press or someone like that?
Gotcha.
Do you think?
And then a judge could order it. I got you.
Yeah. Just kind of separating those out into two different exceptions.
Sure. I think we'll get there. That's a good idea.
Yeah, okay. Vice Chairman Washington.
Thank you, Mr. Chairman. Good morning. On page 2, line 14, can you give me an example of when the Department of Corrections would be involved with releasing a mugshot of someone being admitted into custody who has not been convicted? It seems to me that the Department of Corrections only deals with convicted individuals.
Representative Banks.
Mr. Chairman, you are correct. That's the way I interpret it as well. Obviously, the terminology came from LSO to place the Department of Corrections in there. But obviously, by the time you have reached the Department of Correction, you have already been committed or already been convicted of a crime. So I think that would be very, very narrow or minor in any kind of circumstance where the DOC would not release a mugshot.
Representative Provenza, and then Representative Rodriguez-Williams.
Thank you, Mr. Chairman. I believe maybe this is something that LSO talked with you about, but wouldn't there be possibility for, say, an arrest if someone who is incarcerated commits another crime? And so that mugshot wouldn't be able to be disseminated because it's a new crime, an alleged new crime versus someone who is versus their mugshot that was taken previously and then they were sentenced and convicted.
Representative Banks.
Chairman Olson, correct. I think that could be the only situation really where that may apply. Yes.
Do you get them if you're already incarcerated and you commit a crime inside of the prison? You get another mugshot? You go through the same booking process? Okay. Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Thank you, Representative Banks, for being here. Just a brief question. Does this bill hinder at all the sheriff's websites that post booking photos? I question whether or not, in a world of rapid sharing online, whether or not this bill would actually help in the real world, because anybody can go online to a sheriff's website, look at booking photos, screenshot them and share them on social media or other media outlets.
Representative Banks.
Chairman Olson, it's my understanding that this would prevent that. And you're right. I will tell you, my daughter is obsessed with those websites and is on there all of the time. But it would prevent that so that those are not public. You could see who was arrested, but you would not see their mugshots.
Representative Oakley.
Thank you, Mr. Chair. Representative Banks, you and I discussed this, and then you just mentioned here today that your sheriff was going to testify and then is not going to, but I'm interested because when we discussed it, I said, reach out to your county sheriff, and you clearly did. So will you tell us what his thoughts are? Because I can say this doesn't happen in my county. So I'm interested because it seems like possibly one of the fixes could be just internal county policy. So and not doing this practice. So if you could share with us what your sheriff wanted to say.
Representative Banks, sounds like hearsay, but we'll admit it.
Chairman Olson, yeah, I don't know that I can speak for him. He is supportive of the bill itself. I'm not so sure if he feels he has the leverage not to share those photos because it is part of, right? When you look at statute 7-19-106, one of the things that is shareable on there or is subject to public share is those booking mugshots when you pull up the whole statute. And so I'm not so sure he feels like he can't do it. Now that I don't know that he couldn't perhaps negotiate with the local media outlets that share those already. However, this is really clickbait for those folks. And so I'm not so sure that they're willing to give that up without legal pushback, frankly. But he was supportive of the bill. For other than that, I can't tell you much more of his opinions about it.
Vice Chairman Washit.
Thank you, Mr. Chairman. The word release. Publicly release, share with other law enforcement agencies, use internally. I guess the term release seems pretty broad. I understand, I think the intent of your bill is to prevent the release to the news media for publication, as opposed to releasing to detectives or to DCI or to some other agency for investigative purposes or internal use. So how would you define release?
Representative Banks.
Chairman Olson, yes, release means in a public fashion. And I was going to try and pull up the statute, which I do have here really quickly. But this really deals with only the public dissemination of information, not shared among law enforcement, where you would also, I assume, again, you obviously have the expertise in this, but where you could also share criminal history, those kind of things. This would not be subject to internal shares or shares among agencies, that kind of sharing.
So Representative Banks, are you saying it's defined in the existing statute?
Chairman Olson, that's my understanding, and I was trying to pull it up here. So the Wyoming Department of Corrections and county jails may release the following information regarding any individual except juveniles, yada, 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 who has or has been committed to supervision and custody of the Department of County Jails, unless this will compromise the safety. And so it goes into those where they may release those. And the photo is one of those. And so this removes the photo in many cases from that public release information.
So then Representative Banks, so, okay, that's you're looking at page 3 of the bill, lines 6 through 14. That's new language. I see you're using that to define release, but it doesn't look like we actually define release in the existing statute.
I'm not so sure, Chairman Olson, I'm not so sure that the word release is technically defined in the statute, but it is used in the statute as far as what that applies to in the actual statute itself, not the suggested addition of section O.
Now that I'm looking at this language, I am a little confused in that Romanet 2 at the top of page 3 says a judge can order the release or dissemination of the information if it furthers a legitimate law enforcement purpose. Then line 4 says, or. Then line 6 says a criminal justice agency requests the release of the photograph. Who's it request? If it's requesting it to, does it have to request it to the court, or I think the scenario that Vice Chairman Washit was just laying out to me envisions the criminal justice agency determining on its own that it needs to release the information. Does it still require it to go back to the court?
Chairman Olson, I believe if we put in the amendment, excuse me, suggested by Representative Oakley that takes out that judge order, then that even clarifies that more, so that then those criminal justice agencies could share much more easily among themselves.
But again,
if that's the way I read that.
Well, I think it will hinge on the word request on line 6, though, Representative Banks. If you're going to, you have to make a policy choice there, and maybe you have a recommendation for us. Is your vision that the agency will in fact go in front of a judge and request it in some way or another for whatever purpose? Or is your vision that if the agency determines that it would further its legitimate law enforcement interests, that it could just release it and then it wouldn't have liability for releasing it?
Chairman Olson, correct. I think that, like I said, my intention is not to tie law enforcement hands whatsoever, especially when they are, when there's in these cases that are sort of spelled out, when there's a fugitive, when they need help apprehending someone, when somebody is an imminent threat to the community, to other individuals and so forth. And so I think removing that would certainly clarify it for sure.
And then just going back to Vice Chairman Washat's question, would you be adverse to some type of an amendment on page 2, line 15, where we qualify release of the photograph by saying something to the extent of the release of the photograph to, I don't know, we'll just say in general to third parties, right? That are not public parties, public release, something like that.
Chairman Olson, correct. Yes, that would be certainly amenable to me.
Okay. Representative Provenza.
Thank you, Mr. Chairman. So on page 3, the Romanet 3, doesn't that apply to I believe subsection O? And so it wouldn't be necessarily referring to a judge. It says a criminal justice agency requests the release of a photograph, and that's under O, and that's referring to Wyoming Department of Corrections or county jail. So my interpretation of that would be another criminal justice agency requests the photo from DOC or county jail, and they're able to obtain it without applying subsection or Romanet 2.
Representative
Chairman
Banks.
Olson, because there is an or there, is that what you're saying? The or allows that? The or on line 4?
Mr. Chairman, what I'm pointing to is that these are Romanets under subsection O. And so, yeah, the or would mean that Romanets 1, 2, or 3 apply to O.
So Representative Provenza, I think the confusing part is criminal justice agency and county jail. So when we say county jail, we are referring to our sheriffs who run our county jails. But if the sheriff is the criminal justice agency that wants to post it, then I agree with your reading, but it would mean the sheriff asks himself if he can release it. So I think that's why under the one scenario where they would ask the Department of Corrections, where it's your scenario given earlier, where you have somebody already incarcerated, I think that would line up. It's just a little confusing when the sheriff is the agency himself or herself. Does that make sense, Representative Banks? When we use the language criminal justice agency, do you know if that is defined in statute, that we know who we're talking about? It is, Representative Yan, and what does it include, Representative Yan?
Mr. Chairman, 719-103 A, Roman 3, criminal justice agency means any agency or institution of state or local government other than the office of the public defender, which performs as part of its principal function activities relating to agencies that hold criminal history and records. So, or are involved in criminal justice, essentially. There's a big A and big B, but I don't think it's necessary to read that. I think it's pretty clear cut.
Representative Craigo?
Thank you, Mr. Chairman. Just to follow up on that question, it does not mention federal criminal justice agencies? Okay, thank you.
Did you have a follow-up, Representative Provenza? No. Vice Chairman Washington?
Thank you, Mr. Chairman. What is the penalty for a sheriff who violates this?
Representative Banks?
Thank you, Chairman Olson, Representative Washit. I would need to pull up the statute as well, because the statute spells out what the penalty is as well.
Does the sheriff get booked and his or her mugshot gets released?
Right. I will look that up for you, Senate Representative, and get back with you.
Any other questions for Representative Banks? All right, when you do find it, just holler out to us and let us know. Did you have anything else, Representative Banks?
I do not. I appreciate your time.
Excellent. I see some agency folks here. Director, are you here to testify on this bill? Okay, all right. Okay. No agencies wishing to testify on this bill, then let's go, Carol, to the virtual world and let in Wing Lu. Good morning and welcome. Please introduce yourself. And if you represent an organization, let us know what that organization is, and then we'd be happy to hear from you. Can you hear us?
Are you I'm not sure. Are you talking to me?
Yeah. Yes, sir. Please go ahead and introduce yourself to the committee. And if you represent an organization, let us know. If not, that's fine. And then let us know what you want us to hear.
Yeah. Good morning. My name is Wing Lu. I am a lifelong resident of Rock Springs, Wyoming. My family is current hospitality business owners in the community for over 50 years. And I've been asked I have asked Chad Banks for this opportunity to relate to you my personal experience that happened to me on the night of May of 2020 in relationship to the proposed mugshot bill. So on this evening, about 11:30 at night, I was on my way home from work, and I was pulled over by Rock Springs police for failure to maintain a single lane of traffic. And I was subject to a field sobriety test and a breathalyzer test. I did pass the field blow test, but the physical sobriety test, I didn't do so well standing on one leg. So I was thrown into the police vehicle and taken to county jail, Sweetwater County Jail, and I was incarcerated. But before I was incarcerated, I was they had me blow into the the stationary big monitor machine at the jail, and there I also blew a zero. So I blew zero in the field. I blew zero out in the county jail on the big monitor itself. So they asked for permission to take me to the hospital to get a blood draw for further analysis. At that time, I did consent to that. They did take me in a patrol car up to the hospital and take my blood. But after that, then the officer wanted to do another test, and which was not hospital related, was supposed to be done by a police officer. And at that point in time, I decided it was probably a good idea to call my lawyer. So on the way back to jail, the arresting officer told me I was getting bonded out. Before I got bonded out, I was booked into the jail. My mugshot was taken, and I assumed I was charged for DUI alcohol. That was my assumption, because I was assuming that's what they were trying to arrest me for. I didn't pay attention to my arresting documents, but the next morning, I did talk to my lawyer. We were able to ask a couple of the media outlets to not publish my mugshot in two of the media outlets, but we missed the third one because hardly anybody reads that one, unfortunately. So that morning, I was woken up at 6:30 in the morning. The next morning, my wife says, "Well, you forgot about the Rocket Miner, which is the local newspaper, and then on rocketminer.com, my mugshot was there." And the charge at this point in time was not only it wasn't DUI controlled DUI alcohol. It was DUI controlled substance. I was pretty disappointed and actually very, very mad. So I talked to my lawyer, and we had to wait for the straight crime lab results to come back from the blood draw before we could do anything. And so my blood work came back. This was so I was arrested on May 22nd. My blood work didn't come back from the state until late July sometime. It actually sat on somebody's desk at RSPD for a couple weeks before my lawyer made a call for somebody to look for it. And my blood results came back 0 for alcohol, 0 for controlled substance. So a few weeks later, the judge had all the charges dismissed against me, including, and I was not charged for anything, not even a traffic violation. So during this whole time, I'm dependent on myself and my family are dependent on the patronage of the local community for a living. I was extremely embarrassed of what happened. I wasn't sure if a lot of people that I knew, whether they knew I was arrested, or should I even say anything to them, or were they embarrassed to say anything to me about it? I was wondering, well, were a lot of the people in the community not patronizing me because they didn't want to patronize a person that was possibly doing something illegal, pills or meth or otherwise, while preparing their food. My wife was extremely embarrassed because she's actually a certified nurse midwife in the community. She delivers babies. And then when my high school age kids were also embarrassed because, they, everybody looks at those posts to see if who got arrested. So all the charges were dropped. However, the media outlets are quick to publicize arrests, but they take no responsibility in any publication of any dismissals. And there were at any point in time there was no public apology, which I requested from the police chief regarding my arrest, because obviously it was an arrest that shouldn't have never happened. And because they had actually zero proof. They had zero proof of saying that I even had anything illegal in my system that impaired my driving. they didn't even charge me for a traffic violation after everything was done and over with. I did, however, get a private apology from the police chief, but not a public one. So, and I've never been in jail before, ever. And I did pretty good. I made it to almost 60 before I before I actually got thrown into jail. So I definitely urge your consideration on this bill, because what happened to me was extremely wrong, and I did want to publicize and pay for it if I had to, a public accounting of what happened to me. But then at the urging of a fellow business owner, they told me not to, because it would just kind of stir the pot even more. It would best to just let it die. So, whether I know from my personal level, I was humiliated and embarrassed. Did I suffer financially? Hard to tell. My product sells. The quality of my product helps me to make sales in the community, because that at the end of the day, that's what it's all about. It's what I sell. But in relation to that, I asked the police chief in summation, says, Dwayne, what do you think a person's honor and reputation are worth? And he was quick to answer. He told me it was worth everything, quote unquote. And that is why I'm testifying to you, because I was extremely embarrassed, and I'm still at this day still mad about it. And what law enforcement could have done is not waited for the test results to come back and then issue a bench warrant for my arrest if I did indeed test positive for alcohol, and especially controlled substance. Had I been drinking and driving and I was over the legal limit, then I would be fine with that. Then, shame on me. Shame on me. I would be a threat to public safety on the roads. But to charge somebody for DUI controlled substance has a way different connotation. And so that's why I'm here today. Thank you for this opportunity to talk to you about this.
Thank you, Mr. Liu, for sharing your story and your comments on this particular bill with us. I think I could speak for every member of the committee that we certainly empathize greatly with your situation.
Thank you.
Definitely sorry that you had to go through that. Committee, do you have any questions for Mr. Liu? All right. Once again, thank you for sharing with us today. Anyone else wishing to testify on this bill? Please come forward. We found the food truck.
He's cool. So it's a pleasure, Mr. Chairman and committee, to be able to sit here and have a conversation with you all today. My My name is Megan Jensen, and I currently reside in Rock Springs. I've had the excitement of raising 5 children who've attended or are still attending the school district in which the good representative who has brought this bill resides. In the last 5 years or so, I've attended school functions where administration states that pausing before you post is good practice. And also that it seems that many institutions such as themselves feel like they're 10 years behind all the issues that social media presents. I think that this bill is probably a good start. The type of behavior that comes with posts such as though these becoming viral is concerning in itself as a community member, but as a time of as a full-time step parent of most of my children, I hope that you can understand why this is a good bill and should be allowed to continue. So I'd like to thank you for your time, and I'll hang out for a moment if you have any questions.
Thank you, Ms. Jensen, for sharing with us. Committee, do you have any questions? All right, and we will definitely take you up on your recommendation of good food in Rock Springs.
Thank you.
Anyone else wishing to testify on this bill? All right, I will.
Chairman,
Oh,
we have one other person who's come in.
that was really close. The gavel was coming down. Who is it, Carol?
All right, I'll bring him in. Dwayne Pacheco. Mr. Pacheco?
Mr. Pacheco, you've been admitted. Go ahead and light up your camera so we can see you. Go ahead and introduce yourself and let us know what you want us to hear about this bill.
Thank you, Mr. Chairman. My name is Dwayne Pacheco. I am the police chief here in Rock Springs. And I just wanted to speak in support of Mr. Banks, Representative Banks' bill. And also to just let you know that what Mr. Wing Liu described, very true. You know, a lot of people wake up to other people's a bad night, if you will, and the court of public opinion is automatically guilty. And as I told Mr. Liu when he came in and spoke to me, you know, this is the proper remedy for to address this situation, because every arrest that we make, whether people are, and our burden is probable cause, not beyond a reasonable doubt. People are not always guilty. And of course, in our press releases, we write that, but at the very end of our press releases, but of course, nobody ever gets to the last part of the press release, only the first part, the good part. So with that, Mr. Chairman and committee, I just would stand for any questions and just speak in high support of Mr. Banks's bill. Thank you.
Thank you, Chief Pacheco, for joining us. And we really appreciate that. It's one of the things that we do appreciate about our Zoom meetings is we can get people from all over Wyoming involved in our testimony, and you don't necessarily have to take a couple of days to drive all the way over here. Committee questions for Chief Pacheco? Representative Oakley?
Thank you, Mr. Chairman. Thank you, Chief. I am interested, if you're willing, sorry to kind of put you on the spot here, but with the description that Mr. Liu gave, have you reviewed that arrest? Because when we start discussing cases and then that's going to make law, I think it's important. And I hope that what we're discussing is very much an outlier. So since you are here today to testify, because I hope it's not very often that we have completely innocent people booked in. And from what I've heard, this is an interesting case. Have you reviewed that? And do you have anything about that?
Chief?
Mr. Chairman and Representative Oakley, absolutely. We did review that investigation and arrest along with the city attorney. And we did meet with Mr. Liu formally, and I've also met with him informally. As I said, our burden for arrest is probable cause, not beyond a reasonable doubt. And of course, with the probable cause, video camera, all of those things that we reviewed, we did have a probable cause to make that arrest. Now, the system did work. I will tell you that because it went through the system once you're in the system, and obviously the charges were dismissed because there were, as Mr. Liu said, once the chemical testing and such came back, there were no substances in that in his system. And without getting into details about that case, I will just leave it as, yes, we do have a review system. We did review it appropriately, and I believe that that the officer did have probable cause. As far as you know, there was a request for an apology, and as I told Mr. Liu, the system worked the way it should work, and and to your point, ma'am, very few cases are of this nature. I believe the point of this bill, though, is that mugshot that is put out contemporaneous with the arrest, and that does cause some, I shouldn't say some, but a lot of issue for the subject or suspect.
Follow up, Representative Oakley.
Thank you, Mr. Chair. So along with that, then if you said that when that mugshot is put out, if you recognize this could be possible, have you decided or looked at your policy? Because when you say when that mugshot is put out, isn't it your agency that's doing the press release and putting that out? And what about discussing your internal policy and not doing that rather than expecting a law change? Do you have any thoughts on that?
Mr. Chairman, Representative Oakley, absolutely. As I said, this is the appropriate, I feel the appropriate venue and remedy simply because once we arrest somebody and they go through the doors of the jail, is actually up to those rules come from the jail and county sheriff. We have no control over those policies or procedures that they push out that information, and it's really through Jail Tracker, and it's statewide. Even other states, you'll see that depending on what their rules of release are, those mugshots will find their way to media.
Vice Chairman Washut.
Thank you, Mr. Chairman. Chief, appreciate you joining us this morning. You said the system worked, but it sounded like it took quite a while for the chemical tests to come back from the laboratory. Is that a common occurrence when you send chemical tests into the DCI lab, that we have to wait a long time to get results?
Chief.
Mr. Chairman and Representative Washut, it just depends on what their caseload is, how many analysts they have, all of those types of things. And we work together. The wheels of justice move very slow, as you all probably well know, especially if you're on the receiving end of it. Mr. Liu did refer to it sitting on someone's desk for a couple of weeks. Our detectives, I should say our investigators, our police officers, they are busy. But once again, these results come back, they go to the officer has to write a supplemental report, it goes to the county or to the city prosecutor. So there is a time lapse there, and depending on caseloads and such. So a lot of different variables in place, if you will, to speak to the timeliness of how that gets through the system.
Further questions, committee? All right, Chief, thanks for joining us. Representative Banks.
Chairman Olson, I did review that statute. There is no penalty phase or no penalty statute information in there if this were released. So.
All right, thank you. Anyone else wishing to testify on this bill? All right, I will close public comment. Committee, what is your pleasure? Moved by Representative Yin, seconded by Representative Provenza. Amendments on this bill? Amendments on page 1 of the bill? Page 2? Any amendments on page 2? Page 3? No, Representative Oakley.
Okay, I'm gonna make an amendment. It's significant. So page 3.
We're ready, Representative Oakley.
Okay, and even then, I kind of have to, my amendment is to, on page 3, delete lines, the entire page, delete lines 1 through 14.
Okay, is there a second on that amendment?
Is that it?
What, no,
Oh.
I think she's still going.
Well, she wanted,
And then,
I thought she was just
sorry.
deleting page 3.
well, that too, but instead, so to make,
Oh, you're gonna replace it.
to replace it,
I'm
yeah.
sorry, go
so,
ahead.
So that would leave, then there's still obviously subsection 1, I on page 2. So to start with, in a subsection 2, this says for any legitimate law enforcement interest or purpose.
She said that.
Okay, so I think she's just replacing it with basically the language that you see on lines 3 and 4 for any legitimate law enforcement interest or purpose. Did you get that, Carol? Okay, so Carol, the motion is to delete or the Romanet 2 and 3, lines 1 through 14 on page 3, and replace it with Romanet 2. Right, Representative Oakley?
Yes,
For any legitimate law enforcement interest or purpose.
with an,
And then we may need some language in
It would
front
be
of
an-
that, right?
yeah, we might, and then an.
So it
or
would
on
read-
one.
Subsection O would read, process of admitting the individual into the custody unless and you need some kind of language in front of for lists. Okay, so
Unless
it would
the
read,
release or dissemination is for,
yep. Unless the release or dissemination of the photograph is for any legitimate law enforcement interest or purpose.
I think I'm going to have to get with Representative Provenza or Oakley to figure this out. Okay, I'm sorry.
This is it, Carol. Okay, this is the Romanet 2.
Okay, Romanet 2 on page 3.
Mhm.
Okay. And
The
it's
release,
unless, start with unless.
unless, no?
Right?
The less is in the previous sentence.
Okay.
Okay, here we go, Carol. Ready?
okay.
We're ready this time.
Okay.
The release or
For-
dissemination of the photograph for any legitimate law enforcement interest or purpose.
For purpose.
Does that sound right, Representative Oakley?
Yes,
Okay, we have a second on that amendment. Seconded by Representative Swanitzer.
I have a question.
You have a question on the amendment, or you want the question of the amendment?
discussion.
Discussion on the amendment, Representative Swanitzer.
I guess my primary question is who decides on the legitimate law enforcement interests? Is that law enforcement itself in your mind? So they get to decide if it should be put out or not at the discretion of whoever the chief of or the director of corrections? Does that seem odd, I guess is my question.
Representative Oakley.
Thank you, Mr. Chair. Yes, I mean, they are the custodian of the records. And what I tend to see and that I actually still believe is that the statute, even at the beginning, says may release. So I would think that, and again, in my county, the law enforcement could do this already. I don't necessarily agree with what I've heard that from sheriffs or other counties, or that we heard testimony here today that they couldn't stop that practice. But so this takes a step in saying it should be for a legitimate law enforcement purpose. So as we heard from Representative Banks, that would make it so if they feel like media is going to that they have to give it to the media. This pulls that back. But but it also needs to be, they need to be used. The reason they're taken, I mean, they're used for identification and all the time. And I would hate to see that stifled. As a prosecutor, you know, that's how they bring over a mugshot. We identify them in court sometimes because we can, yes, they were arrested 2 days ago. Look at that, make sure that's the same person for identification. I would just hate to stifle that. So I think this gives the protection that the representative is looking for without going too far.
Committee, Representative Zwanitzer?
So then if you weren't convicted of the crime, your mugshot was out there, your remedy is to go back and say, I mean, you're going to issue a lawsuit against the police department saying it wasn't legitimate law enforcement interest. I don't think legitimate seems to be an interesting word in the law on who gets to decide and how you would ever argue against that is my concern. But are there ways to do that, fellow attorneys on the committee? Or I would say law enforcement in all cases would say it's legitimate, and your course of action is to somehow say there is some nefarious plot by law enforcement to really ruin your reputation, I guess.
Representative Oakley?
Well, I think along with that, you just said a nefarious purpose. I mean, I think our law enforcement tries to follow the law. So I don't see that this says don't disseminate it to, unless it's for law enforcement, not the media is what I think what we're getting at. And so it's there.
Committee, additional discussion on this amendment? Representative Provenza?
Thank you, Mr. Chairman. I think the concern is the issue of what release is. And so I hesitate to take judges out of it because I think there might be instances in which maybe law enforcement isn't releasing for some reason. A judge might see that that is legitimate. And so maybe the solution is, instead of taking out all of page 3, we have a process for public release, which is much more stringent and then allowing law enforcement to share files, documents, photographs with each other without trying to infringe on their ability to have that back and forth communication with mugshots.
Additional discussion, committee? All right, you ready to vote? All those in favor of this amendment signify by saying aye.
Aye.
All those opposed? Okay, that amendment is adopted. Carol, can you just read back the language? I know everyone knows what the purpose of the amendment is they were voting on, but I'd like to make sure we've got it.
So what I have here is for any legitimate law enforcement interest or purpose.
So the amendment deleted the language on Romanet 2 and 3, lines 1 through 14 of page 3, and replaced it with the release.
The release, thank you.
Yep. The release or dissemination of the photograph is for any legitimate law enforcement interest or purpose. That should be the sentence.
Okay, I've got it.
We got it?
Mhm.
Okay, great. Committee, additional amendments? You want to discuss this, Bill? Go ahead, Vice Chairman Washut.
Thank you, Mr. Chairman. I just asked the committee to think about what testimony did you hear this morning specific to the mugshot? The problem that we heard about was about a man whose reputation was besmirched by the release of information about his arrest. Whether or not his mugshot was included in that release seems superfluous. The same damage would have been done to his reputation had the headline in the local newspaper with a stock photo of some image of this businessman taken at a Chamber of Commerce event had appeared in the newspaper saying, local businessman arrested for driving under the influence of controlled substance. Whether or not the sheriff released his mugshot at all. So I don't think this bill solves the problem that we were asked to solve, which really dealt with the release of the arrest information. We didn't get anything specific to the mugshot. The mugshot itself wasn't the problem. It was the story. And I would argue to the committee that this bill doesn't fix that situation. I'm a no vote.
All right, committee. Representative Rodriguez Williams.
Thank you, Mr. Chairman. I too will be a no vote. Nowadays, anybody can drive by a police scene and video with their cell phone or take images with their cell phone and snapshot the person that's in handcuffs and spread that information. Furthermore, names are also released in the newspapers. People can take pictures of newspaper police blogs and put that on social media. I too don't believe that this solves the problem.
Representative Yin.
Mr. Chairman, just to maybe push back on that a little bit. A mugshot, as Representative Oakley mentioned, is a piece of identifying information. While it's the name could be released, other information could be released in booking documents. There could be multiple Adam Smiths. I think in this specific story, Mr. Liu is a very unique name where it'd still be possible to identify him, but the booking photo itself, not only is it a capture of a person in a state where they're not at their best, it is one that identifies them as specifically the person that was booked in that situation. I don't see a legitimate purpose, and most of the time when they're on these websites, I think there are plenty of legitimate purposes, and I think the bill is very good at, especially with the amendment, at allowing free reign for law enforcement to do it if they need to. But if the whole purpose, if there isn't a purpose and the purpose ends up being used just for clickbait for the newspapers or websites, I think it'd be useful to rein that in back in a little bit. If there's a way for us to target this specifically for those websites, I'd be appreciative of that. But I think that what the issue at hand here is that those mugshots get released to the public, and once they're released to the public, you can't rein that back in. So this helps to do that. So I'm an aye. Thank you, Mr. Chairman.
Representative Provenza.
Thank you, Mr. Chairman. One of the greatest things about this country is that we are presumed innocent until proven guilty. And there is a difference between what we publish as a mugshot versus a Chamber of Commerce photo. Mugshot is taken at perhaps maybe the worst moment in your life. You may be in clothes that are from the jail instead of your civilian clothes. And that indicates things to people. And so what the police chief from Rock Springs said was right. It's the court of public opinion is pretty harsh. And that public becomes our jury. And so if we are truly to respect innocent until proven guilty in this country, we should take whatever we need to protect that. Because I think it is the basis of our democracy and our justice system. I'll stop there, but I know that this isn't an isolated case. I know that I've seen this in multiple folks with very similar case findings as Mr. Liu. And so to protect people of Wyoming, photos can be published after they're convicted, but let's just respect the rule of law. Thank you.
Char, you only get one bite at the apple. You ready to vote, committee? Representative Zornitzer, you'd like to say something?
I'd like to bring an amendment. And,
Oh, we've already passed that,
What? Why would we?
but go ahead.
Why would we pass that?
Well, I thought we were on the point of why we like this bill and don't like this bill.
Oh, I think that's all part of discussion amendments, right? Isn't that the point of discussion that we can amend the bill? Should the discussion lead to that?
I like to separate it, amendments and then discussion.
All right, so, something.
Mr. Chairman, I will give deference to your
I-
desire to amend this bill.
I appreciate that. So it's probably gonna be on page 3. It's gonna be a new Romanet P, I guess, a new subsection P. I'm just guessing the O is, I'm not getting my statute book quick enough, but let's for now call it P. And it says, I'm gonna work in the language, Carol. No publisher shall use, I use the word mugshot, is that in here? A photograph? How about no publisher shall use a photograph of a individual suspected of a crime for financial or personal gain. That puts I think that's where the intent of the bill is, right? You have these entities out there that are, in fact, using this information for their desire for financial or personal gain, which is not what should be happening.
Representatives Wanser,
Yep.
would you use the language, so no publisher, shall use a photograph taken of an arrested individual during the process of admitting the individual into the custody for the purpose of pecuniary or financial gain?
Yes, Mr. Chairman.
Yep. Okay, so no publisher shall use a photograph, and I'm just looking at Carol on page 2, lines 15 through 17. I'm stealing that language. So I use a photograph taken of an arrested individual during the process of admitting the individual into custody for the purposes of financial gain. Okay. We have a second on that amendment. Was that a second, Representative Craigle? But you'd like to discuss it. To discuss it, you need to second it. Okay. Representative Provenza seconded that motion, Carol. Now, Representative Craigle, go ahead.
So I just have a question for the bringer of the motion. Does this apply to all booking photos, previous booking photos, only the current photo? Because we could be talking about somebody who's been arrested multiple times. The newspaper might have the previous photo from 10 years ago. Can they not use that, or are we talking only the current photo?
Representatives Wanser?
So, Mr. Chairman, I assume it'd be any photo taken after the passage of the law. But they could use, as long, I mean, it's the point of the amendment about the financial gain, right? And a reputable newspaper, you would argue, has legitimate interest in possibly publishing a mugshot for community information, for news. But from what I understand, it's 2 sites that I looked up quickly. I mean, that's their main purpose, I think, is to draw views. It's not about the public safety interest. It's about and that would be a lawsuit for those, should you even be able to file it. But I think that's really the intent of where we're going. But on the photograph itself, I don't think it matters if it's a current mugshot or a former mugshot. I follow a person online who's got 18 mugshots. That's how I know where he is in the country, is I just see who arrested him recently. And so, yeah, I don't think it's about the photograph. Any mugshot, previous or current. It's more for my amendment about using it for a purpose for financial gain, not for reputable news. And I think that's maybe the burden and the onus of where this bill is going. We don't want to restrict legitimate public interest. We do want to restrict people using it for clickbait reasons.
Representative Yin?
Mr. Chairman, I think the mover did bring this amendment based on my discussion, but I'm not a First Amendment lawyer. Is there an issue there? Okay. Thank you, Mr. Chairman.
Representative Larson.
Yes, Mr. Chairman, thank you. I'd like to ask the good representative, is there a penalty for this? I thought I heard earlier there is no penalty for this. And also, who would make that determination if they're there for to make money or not? I think everybody's there to make money.
Representatives Wanser?
I don't think there's any criminal penalty. It would be a civil remedy that you would go after one of those sites saying there's no legitimate purpose in you publishing that information besides to drive web traffic to your site, and they certainly have a defense saying we're a reputable, legitimate organization. So I don't know if it solves the problem, but I do think that's more of the intent from what I understood from the testimony is we don't want these websites whose sole purpose is to find us to cause ad traffic to their site. So no criminal penalty, but civil course of action.
Yeah, Representative Larson, I think one of the distinctions is your civil remedy against the sheriff, for example, or the police department is pretty limited by governmental immunity versus a public or a private publisher. You could bring a civil action and you would just have to, the jury would, or the judge would be the arbiter of whether they did or did not use it for financial purposes. Not to speak on the amendment, just trying to clarify a little bit for you. Vice Chairman Washit.
Thank you, Mr. Chairman. You know, over the last few years, Judiciary Committee has taken up different bills that had some implication of the news media, and we tried to differentiate between traditional news media and social media, news media, and individual bloggers. And it's a slippery slope of the First Amendment when you start trying to, you know, limit the activities of a particular media outlet. And I just urge a no vote on the amendment.
Committee, are you ready to vote on this amendment? All right, question on the amendment. All those in favor signify by saying aye.
Aye.
All those opposed? No. Sorry, Representatives Warrenser. Any other amendments on this bill? Carol, the only thing I will clarify on the Oakley amendment, on page 2, after Romanet 1, before, after the semicolon, we need an or. And that was just part of that amendment. Okay. Committee? Carol, will you please do a roll call vote on House Bill 51 prohibiting the release of mugshots unless convicted?
Representative Craigo,
Nope.
Representative Larson,
No.
Representative Oakley,
I'm going to be an aye vote here.
Representative Provenza,
Aye.
Representative Rodriguez Williams,
No.
Vice Chair Washit,
No.
Representative Yen, Representative Zwanitzer, Chairman Olson.
Thank you for that. Aye.
5 ayes, 4 noes, do pass with amendments.
Thank you, committee. Good work on that bill, committee. Thank you, Representative Banks. You will obviously want to floor manage that. We can take care of the amendment and then we'll hand it over to you though. Thank you. Just so I can get a sense, so I can judiciously walk through my time here. Who is here to testify on House Bill 88? All right. And what I'm going to do is I'm actually going to switch up the order a little bit. I'm going to take up House Bill 88, Representative Craigo, if you don't mind, just because I think it will move quickly. And then we can use the remainder of our time on your bill.
No problem. Thank you,
right.
Mr. Chairman.
House Bill 88, name change notice publication of minors amendment. You can try to grab him. If not, Representative Oakley and I are co-sponsors. We can burn some time on it while he shows up. Well, I told him All right, committee, as we're coming back, Clayton, we noticed you joined us on Zoom, and I'm just letting you know, and for anyone else out in the public who might be here for House Bill 71, we are going to take that up after House Bill 88. So switching up the arrangement a little bit here. So we are now moving to House Bill 88. So bear with us out there in the virtual world. Representative Harshman, welcome.
Morning, Mr. Chairman, members of the committee, I should say. Thanks for moving me up, I guess. I was working on some other stuff, appreciate it. And small little bill here, really a constituent bill. Of course, most of the bills we probably bring over time are from folks that get a hold of us. And this was a young mother, had a young child, and dad's in prison for a long, long time. And they both agreed to change the name back to her name, but there's other family. This was the whole story, and it got really kind of complicated. And so just really, so then I contacted the Department of Family Services, visit about this. You know, they're the experts really that deal in this space. And so really just going into this Title I, and it's just under the publication. Right, doesn't affect any other part of the whole name change process, but the publication part that has to go in the newspaper, just like other legal ads. And so really just to take that piece out of a minor child doesn't, you know, any other parts of that, is my understanding, doesn't affect any of that. It's just the publication piece. So that's what I was trying to do. And I'm sure your committee, if there's a little word or two or another sentence you need to add, make it a little better, that'd be great. So, Mr. Chairman, I think that's the bill. So thank you. And I think Department of Family Services is here. I had a little info as well.
Okay, committee questions for Chairman Harshman? All right, Chairman, thank you for bringing us this good little bill. Welcome, Ms. Chambers.
Thank you. Good morning. My name is Kara Chambers. I'm with the Attorney General's Office, Division of Victim Services, but we did speak with Director Schmidt as well. Really just wanted to be here for any clarifying questions as to when this might come up. I'm here mostly because, as you'll see, part of the statute discusses confidentiality in court proceedings, and that's a reference to domestic violence victims, that is a specific caveat to notification. And so we discussed perhaps that in the existing statute, a mother might be covered under the confidentiality, but their children might not, but would have obviously the same safety concerns. And so with that, I would just stand for any questions.
Representative Craigo.
Thank you, Mr. Chairman. And this actually could go to either of you two. I have a little bit of concern about just how broad the language is. And I was wondering if we should maybe put in a provision essentially giving a little bit of discretion to the court, where you go in, and it could even be ex parte, but where the petitioner at least has a short discussion with the judge before they're able to just publish without notice, forego publishing. And I could see a circumstance where for one parent is trying to hide the whole thing from the other parent, signs an affidavit, maybe falsely, but signs an affidavit saying that they're the only parent or they have full custody, and it may not be true. Where at least publishing would give a little bit more protection to the parent who isn't involved. And so, but if, for example, if we're talking about a mother who's worried, has safety concerns, she could go to the judge ex parte, say, hey, judge, we can't publish this, and here's why. And the judge says, you're right, issues an order in that particular case, a minute order, probably very short order saying publication is not required under the statute. Good cause has been shown. Doesn't even have to say why, but can just say good cause has been demonstrated to the court. And so with that, do you think that would harm the intent of the bill?
Chairman Harshman.
Mr. Chairman, I don't think so. I mean, again, it's not a space I deal in a lot. Some of you on this committee do, and Ms. Chambers, you know, I don't think so. I mean, I don't, but I don't particularly know. So.
Ms. Chambers.
Chairman Representative, I think that would be fine, as long as we understand that, it doesn't change anything with the domestic violence situations. I think we're fine. I think that's a reasonable.
Representative Oakley, and then, okay, Representative Oakley, did you have a question?
Thank you, Mr. Chair. I guess I know, Ms. Chambers, that, you avoid trying to weigh into policy, but to get your expertise, what do you see as the downside if you do?
Ms. Chambers.
Chairman Olson, I'm not, to Representative Craig's change or to the
Either or, the bill or proposed changes.
Chairman Representative Oakley. No, we actually see a benefit to this to clarify sort of a fuzziness in the law. In fact, when this question was raised, it was sort of, wait, are we sure we can't do that now? And so I did weigh in with the attorneys at the Wyoming Coalition Against Domestic Violence and Sexual Assault, did some of my own research with the law office, and we're like, this would just make it clear. So we do think it's a benefit, and it makes sense. And then there wasn't that fuzziness of whether or not, we even went down the rabbit hole of like, is the purpose of notification for creditors? Do children have, we really went down a lot of rabbit holes on, why would you need to publish a child's name? So we do believe this would be a beneficial clarification of the intent of the statute.
Representative Lawrencer.
Thanks, Mr. Chairman. Just because I don't know, when you publish name changes, do you publish the previous or current name and the future name before it happens? And so that's a public record forever that somebody for nefarious reasons could go look up what a name got changed to. You put both of those in the paper?
Ms. Chambers.
Chairman Olson, Representative Swanitzer, yes, that's correct. And again, we really thought that the original intent behind publication notification for any type of legal action is for creditors or other interested parties. And so, yes, you would have to publish the original name and then the name change.
Okay. For those creditors stuck in voidable contracts. Committee, any other questions for Ms. Chambers? All right, thank you. Thank you, Ms. Chambers. Anyone else wishing to testify on this bill? Carol, is there anyone in the virtual world who would like to testify on this bill? All right, I will close public comment. Committee, what is your pleasure?
Move the bill.
Moved by Vice Chairman Washit and seconded by Representative Crago. Amendments on this bill, Representative Crago.
Thank you, Mr. Chairman. So my amendment would be on page 2, line 3. Before the word public, insert the clause upon good cause shown to the court, comma.
It's been moved by Representative Crago and seconded by Representative Yin. Carol, did you get our amendment? All right. Assuming you want that P to be lowercase.
No, I want to keep it uppercase, Mr. Chairman.
All right.
Thank you.
It's your choice. Okay. Committee discussion on this amendment? Question on the amendment? All those in favor signify by saying aye.
Aye.
All those opposed? That amendment is adopted. Further amendments on this bill? No amendments on this bill? You ready for the question? Carol, oh, yeah, if you'd like to discuss. You want to just discuss the bill? Go ahead, Representative Oakley.
Thank you, Mr. Chair. Very, very briefly, but I just would like to say that it seems to me to make sense, the idea behind this, that there's some continuity to the policy decision of just recognizing that children are in a different position than adults are. As mentioned by Ms. Chambers, is clearly creditors isn't an issue. And then just also like all of Title 14, the title that has to do with children. There's statutes that lay out confidentiality and redaction when it comes to children in delinquency, in chins, and so our law is replete with recognizing that and having that sort of protection for children. So it seems to fit logically and with the policy of laws in existence.
Further discussion, Representative Craigo?
Thank you, Mr. Chairman. I was just going to kind of make a request of the agencies between now and when we get to the floor, if my amendment has some unintended consequence, that you just get back with us and we can take it back out. I don't want to mess up the intent of the bill because I think it's actually a good bill and has good intent. But if between now and then you could let us know, that'd be awesome.
All right. Further discussion on this bill? All right, question on the bill. Carol, will you please do a roll call vote on House Bill 88, name change notice publication of minors amendment?
Representative Craigo,
Aye.
Representative Larson,
Aye.
Representative Oakley,
Aye.
Representative Provenza,
Aye.
Representative Rodriguez Williams,
Aye.
Vice Chair Washit,
Aye.
Representative Yen,
Aye.
Representative Zwanitzer, Chairman Olson.
Aye.
9 ayes do pass with amendment.
Thank you, Chairman Harshman. All right, committee, one more. House Bill, 71. House Bill 71, driving while license suspended, enhancement amendment, brought to us by our very own Representative Craigo. Welcome.
Thank you, Mr. Chairman. Committee, Barry Craigo, House District 40. So this is just what I would call a cleanup bill in the driving while suspended. Driving with a suspended license statute, which is 31-7-134. And really what we're dealing with here is in Part C, and you don't have Part A within the actual bill draft, but Part C refers back to Part A. And as I explained on the floor during introduction, really what we're trying to do is clean up the situation where somebody would have a suspension from another state, drive into Wyoming, and could actually have multiple suspensions, be, serial driving with suspended license, which happens a lot, actually. Actually, it happens that's probably the case more often than not. And so you would show up in Wyoming, maybe be driving with a suspended license, have several of them from the other state, but would not be subject to the enhancement in Wyoming. You would only be subject to the enhancement in Wyoming if you had 2 in a row in the state. Now, some judges don't read it that way. There are places where the judges actually hand out the suspension. We're just trying to clean it up so it's treated the same across the state. And it's pretty simple. Stand for any questions.
Representative Zwanitzer?
I guess my overall question is, do we do this in other cases for other crimes that have subsequent penalties? We have lots of crimes and misdemeanors and felonies that if you do something a second time, it's a more enhanced penalty. It just worries me a bit that in this case, we'll say, well, in another jurisdiction, we'll count this as a second, but do we do that across our laws in every other instance?
Representative Craigo?
Mr. Chairman, Representative Zwanitzer, so we do. DUI would be the best example. And so that would match up. This would make this match up with, for example, the DUI statute.
Representative Craigo, would this capture a minor whose license has been suspended for, I don't know how many consecutive traffic violations, whatever it is, 3, 6, within 4 traffic violations within a 6-month period? Or some similar type law it'd be from another state, I would assume.
Mr. Chairman, it depends what the suspensions relates to. If you go back, and this language is actually in the bill, if it's related to I think if it's related to driving while intoxicated, it would not, but if it's for some other purpose, it could, if I read it correctly. Ms. Oakley, Representative Oakley might be better one to answer on that because she deals with this a lot more than I do.
Okay, yeah, I think that it's an important question to answer. I mean, it seems to me like the crux of the policy purpose of your bill, Representative Craigo, is to address that substance. A license who's been suspended for some type of substance use, are you trying to capture the minor who has a couple of speeding tickets?
Mr. Chairman, no, I don't think that's the intent. What we're talking about is most likely where somebody has a suspended license due to a DUI, driving while intoxicated for whatever purpose from whatever state. I mean, that's the typical situation we're dealing with. Somebody gets a DUI, get a suspended license, their license gets suspended, and then they go somewhere else and get caught while driving without a license, and then they get convicted of that. This would only apply the second time after they get caught. So your first driving while suspended is sort of a free pass. You get a fine, but you're not going to be subject to the enhancement. The second DUS is where the enhancement comes in. Does that make sense?
It does. So again, I'm not concerned about, I understand the policy position on the person who has lost their license for some abuse of a substance. My concern is about the minor who has speeding tickets. And I understand they would get a warning after they're driving without suspension, but I want to make sure that if we are capturing the 16-year-old kid and giving them a misdemeanor now for driving with a suspended license, that we actually want to do that. And if we don't want to do that, is there a way to carve that out so that we're only dealing with the other folks? Representative Craigo?
Mr. Chairman, so this bill really doesn't deal with that.
Okay.
So that would be your first driving with a suspended license charge, and whether that qualifies as a suspension or not, this bill doesn't touch that. That would be, we'd have to go into the different part of the green books to figure that out. So this really doesn't deal with that particular situation, I guess.
But it deals with all individuals with driving under a suspended license, whether they are a minor, adult, or whatever their underlying offense was that they lost their license for.
This bill only deals with their second driving while suspended, not their first.
So they'd already be in this.
They would have already been convicted of a suspension.
Which they would already have a misdemeanor for.
That's right. This would just be their second misdemeanor, if that makes sense.
Thank you, Representative Craigo.
Yes,
It is
sorry.
still early in the morning.
Yeah, well, I wasn't really picking up what you were laying down, and I apologize. So.
Okay, thank you for getting me there. Committee, further questions for Representative Craigo? All right. Thank you, Representative Craigo. Is our department which oversees offenses on our highways wishing to testify on this bill?
Mr. Chairman, members of the committee, Josh Walther, I serve as the Lieutenant Colonel for the Wyoming Highway Patrol. Just a couple comments for the agency's stance on the bill. I think it does clear up a bit of confusion that we have as law enforcement officers writing, whether it's the subsection A or the subsection C, because subsection A, as was mentioned, does specifically mention other jurisdictions and some wording in there, although subsection C refers to A. There's hesitancy on writing that just simply because it doesn't specifically mention similar laws in other jurisdictions. So what we have is folks who are pulled over in Wyoming have suspensions in other states. And what law enforcement officers tend to do is write under A, even though there's 2 or 3 or 4 suspensions outside the state. So what we would rather have the conviction, at least for the initial suspension or any suspension for that matter, and not necessarily the subsequent conviction, just simply because we'd rather have one and not the other. So we'd rather write under A and know that that's a sure thing, as opposed to writing under C and the potential we would lose that with some interpretations around the state. Although it's not everywhere, it's inconsistent. I think that this language helps to clear that up and will make law enforcement feel much more comfortable in citing under C when it seems appropriate to us with states that are in the non-resident violator compact that share that information. I think it does a good job of clearing that up, and it's simple. For that, that's all I wanted to mention. I'll just stand for any questions.
Committee questions? Wow. All right. Thank you very much for your testimony.
Thank you, Mr. Chairman.
Do I have any other agencies wishing to testify on this bill? Any agencies in the virtual world? Who do I have in the virtual world, Carol? Oh, Clayton. All right, let's let Clayton in.
Mr. Malinkovich?
Good morning. Thank you for having me. It's a pleasure to be here.
Welcome.
Thank you. Mr. Chairman, I gather you were turning the floor to me. Is that correct? Or I don't want to be out of turn or out of order.
My complete silence and just blankly staring at you. Yes, Clayton, please introduce yourself, who you represent, and let us know what you want us to hear about this bill.
Yes, thank you, Mr. Chairman and committee members. My name is Clayton Malinkovich. I am a Chief Deputy Prosecuting Attorney, a county and prosecuting attorney here in Sublette County. I do not specifically represent the agency at this point, but I did draw our Representative Summers to this issue. It has been laid out pretty well by Representative Crago. The issue realistically is that that secondary provision for an enhancement in subsection C relates directly to subsection A, and subsection A says in this state, and it also clarifies to Wyoming's DUI statute. So we have come across this on multiple occasions. I'm sure that Representative Oakley can talk from her own personal experiences in the prosecutor's office that this comes across the desk on occasion. The two situations that I came across that compelled me to contact Representative Summers on this issue is we had a young lady that came through Sublette County. We often have a lot of travelers from the parks back to wherever they're going. She had been pulled over and she had, I think, 14 previous driving under suspension violations in Georgia, if I'm not mistaken. And the way the statute is currently written, we could only write her as a first offender. Then we had another one where a very combative and uncooperative driver, who then became a defendant, had 2 previous driving under suspensions convictions out of North Dakota, had arrived to Sublette County and was working in Sublette County and was continuing to drive everywhere. And when we pulled him over the first time, he had those other, or he was pulled over, he had those previous convictions, and we could only write him for a first offense. In my reading of the driver's license compact, this seems to comport with the intent of the compact, which is to give enforcement to other states' laws. And yes, to the previous question, we do this in DUIs all the time for enhancements, whether that be second, third, fourth, which is a felony. We also do this with enhanced sentences on domestic battery that leads ultimately to a felony. So that's where we have seen it, and it would be wonderful if we could have this changed, and it does clear up that confusion that I don't remember his name, but the corporal from the Highway Patrol. This is often a conversation that I've had with his team members as well as our own sheriff's deputies. And certainly if there's any questions, be happy to answer those.
Thank you, Clayton. I assume this individual scenario that you gave us, that individual couldn't have been stopped for running a traffic light in Pinedale.
That is correct, since Sublette County is the only county in the state of Wyoming that does not have a stoplight. I think this is potential for a tangent into a whole nother conversation, but we do have crosswalks that have stoplights, but there is no stoplight within Sublette County.
Questions, committee, for the prosecutor? All right, we appreciate you joining us by Zoom, and we appreciate your testimony.
Well, thank you for having me. It's been a
Oh, you froze. But I assume you were going to say it's been the most wonderful time of your life testifying in front of the House Judiciary Committee, #1 committee of the legislature. Further testimony on this bill? Anyone else in the virtual world, Carol? In the room? I'll close public testimony. We do recognize you as a lieutenant colonel. All right, we'll close public testimony on this bill.
Move the bill.
It's been moved by Vice Chairman Washit and seconded by Representative Oakley. Discussion on this or amendments on this bill? No amendments on this bill. Discussion on this bill? All right. Carol, will you please do a roll call vote on House Bill 71, driving while license suspended enhancement amendment?
Representative Craigo,
Aye.
Representative Larson,
Aye.
Representative Oakley,
Aye.
Representative Provenza,
No.
Representative Rodriguez Williams,
Aye.
Vice Chair Washit,
Aye.
Representative Yan,
Aye.
Representative Zwanitzer, Chairman Olson.
Aye.
8 ayes, 1 no, do pass.
Thank you. All right, committee, that's it for today. Thanks to the public and thanks committee.